Here we are.
D-minus 10, 9, 8, 7, 6, 5, 3, 2, 1, 0, and lift off.
We're live. This is about the law. Hi, Yoli. How are you?
I'm fine. How are you?
I'm good. Karen Reed back in court on her civil case. She's back in court in her civil case, and I see we have a whole one viewer. Thank you, one viewer. Call your friends. Call your friends, because I put this out on the YouTube and let people know. So here we go. So, Yoli, you are on the West Coast in Southern California. I am in the greater Boston area on the East Coast. And, did you ever think, we started collaborating a little bit. I hadn't podcasted at all until about 2.5 years ago. And right away, you and I somehow met each other on Evil CJ's site. And did you ever think when we first started talking about the Karen Reed case that 2.5 years later we'd still be talking about it?
No. As a matter of fact, I thought it would be over with, like soon. I thought the first trial would be done.
Yeah.
It just keeps going.
Yeah, the first trial was in 2024, and it started in April. I remember it started right around tax day. I'm one of those people that waits to the last minute. And so it started right about then. And it ended the week of the 4th of July. It was the 4th was a Thursday, so July 1st was the day that there was a mistrial. And so we ended up, with a whole different set of circumstances that got us to where we are today. There was a second trial, and for the second time, the jury absolved her, and she was found not guilty of any of the major charges against her. She was only convicted of a last-minute throw-in of operating under the influence. But here we are. Her civil case came up.
Yeah, that's crazy. And the amount of people that are supposedly going to be involved in this case, if the judge allows it, is going to be crazy.
It is crazy, and it's the lead story in all the newspapers. I mean, here is the front page of today's Boston Herald, and it just tells you, scorched earth, Defiant Reed seeks to add 10 defendants to the civil suit. So, folks, yes, I subscribe to the Boston Globe, but, having been a subway strap hanger for years, the Herald is just easier to read. You can't read the big old broadsheet newspaper on it. So I know some people like the Herald, some people don't like the Herald, but why don't we jump right into it? As you pointed out, Karen Reed's attorneys got up and told the court, we are going to bring in 10 new people. So why don't we just jump right to that? And this is Derek Seligson, her civil defense attorney. And here we go.
With the federal court, we're not seeking to have this case removed in the federal court. We started it in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have.
My apologies. I got this out of order. That was Marc Diller, the defense attorney. Marc Diller is actually the plaintiff's attorney representing Paul O'Keefe, the O'Keefe family, and he initially brought a civil action against Karen Reed in the two bars. So I apologize. I got those out of order. So now we're going to go back to attorney Damon Seligson, who represents Karen Reed, talking about his plans to bring in a lot of people. So bear with me. Here we go.
that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Bukhenik in his personal capacity, Michael Proctor.
So he's not only bringing in the Massachusetts State Police as an entity, but also those two officers, because Michael Proctor is no longer on the Massachusetts State Police, but he's bringing in Tully directly, and he's bringing in Yuri Bukhenik directly. So that's the big news in Boston.
Right, and so I guess she's going to point the finger at them, and I guess what her attorney is saying is that not only is she going to point the finger to them, but she's also has civil rights claims against those persons.
Absolutely. Let's get back to her attorney, Damon Seligson.
Those claims would be in the nature of violations of Kearney's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Kearney's civil rights.
Now, those are claims, the civil conspiracy and the actions of those inside of Brian Albert's house that night on January 29th of 2022. Those were claims that Judge Kearney in the initial criminal trials, plural, kind of precluded them from bringing. But it's all coming out. It's all coming out in this courthouse in Plymouth, Massachusetts.
And then a claim against the Town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case.
What he's alluding to here, and as an attorney who's practiced in the Superior Courts in Massachusetts, it's pretty obvious to me, but I understand a lot of people. I was having a conversation with somebody today who didn't really understand that. The O'Keefe's estate attorney brought a case against Karen Reed and C.F. McCarthy's in the Waterfall Bar. So that's one piece of litigation. Now Karen Reed wants to strike back, so to speak, with her own claims. Now, there are a couple of different ways to do that. One is what's called a cross-claim. That doesn't work here. A cross-claim is a claim against a party that's already in the litigation. A counterclaim is much the same. It says that, well, you are bringing a case against me, you're suing me in the vernacular, I'm going to sue you back for an affirmative claim, like civil rights violation or some tort claim, whatever. But if the parties are not in the lawsuit, what happens is a third-party claim. So in other words, there are so many parties on the plaintiff side, so many parties on the defense side. They're not in the lawsuit, but what the attorney is saying here is that it's all the same nucleus of facts. It's all the same basic facts, what happened that night and what happened subsequently with the shoddy investigation. So we want to bring what's called a third-party claim and bring these third parties into the litigation. There's been no motion to do that yet. It's got to be a motion to initiate a third party or a motion to add a third party. I've got them on my computer. And The attorney, as we will see for the O'Keefes, is not really thrilled with that. The judge didn't seem to be overly thrilled with it. Now, there's no motion that's been filed to do any of those things at this point. This attorney is simply, basically raising a trial balloon, to tell the court, this is what we're thinking of doing. At some point, there will be a formal motion, and we'll see what the judge wants to do. It didn't sound like the judge was excited about this idea.
It was a status conference, right? And
Yes.
And a motion to dismiss.
Yes.
That was one of the motions. And so in California, if we bring up something like this, it's not before the court, and the court will not entertain it. The court will say, this is not before the court. If you're going to file a motion, then you need to either meet and confer with the counsel or file your motion. And so it's kind of strange to me that the judge actually listened to all of this, because in California, we wouldn't get that.
I think the same applies in 99% of cases, but the Karen Reed is anything but a normal case.
Right.
I've never seen a case like Karen Reed's. And, you can see in the margin of the video that we're playing right now, which I've paused just momentarily, you can see in the margin, the lower right-hand corner, that Alan Jackson's there. He said nothing, but he was there. I believe there were 6 attorneys that I counted that were there on Karen Reed's behalf. And, I don't know if it has to do with the fact that Jackson flew in from California, your home, or just that the attorney just wanted to bring it up as a trial balloon to let people know. Because what if he just dropped, I hate the word bombshell, but it would be a bombshell if he just dropped all of these things in the court on a third-party motion. Then O'Keefe's attorney could say, hey, this is a shock. This is a surprise. So I know you're right. If there's nothing before the court, they're not going to listen to you. But this is an extraordinary case. I don't think I can compare this case to anything else.
Yeah, that's true. It's a high-profile case, in other words. And apparently the judge wanted, or was not happy that Karen Reed's attorney didn't meet and confer with the plaintiff's attorney, the O'Keefe's attorney. At least I thought that's what happened. He just brought it up in this status conference.
Well, formally, you are correct. However, this has been in all of the newspapers. This has been all over YouTube. I mean, this is not unusual to have a front page article on Karen Reed. I actually saved some of them. And I mean, this has been front page news. Alan Jackson has been very outspoken about the fact that they're going to bring these claims. Not that stuff in the newspapers and YouTube is relevant, but I mean,
Right.
they'd had to have known that this is coming. But let's finish up with Karen's civil attorney, Damon Seligson. Then we're going to give the plaintiff's attorneys equal time.
That would be 10 additional parties coming in. To do that,
Now you see Alan Jackson. Whoops! What did I just do? I do this all the time.
Button.
I did hit the button.
decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be in a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are.
So now the attorneys for the two bars had to sit over on the side because there wasn't enough room for them, but the attorneys are there representing both C.J. McCarthy's and this attorney for the Waterfall Bar.
In the process of completing written discovery propounded to us from the plaintiff, we order extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension?
Agreed.
Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then
How do they do that in California? Here in Massachusetts, once you file a claim, very soon after that, the court generates, or I think it's done pretty much by computer, depending on the type of case. They generate a tracking order which sets forth all of the deadlines. You know, you will finish your deadline for discovery by a certain date. You'll disclose your experts by a certain date. You'll do your Rule 56 motions, which that means a motion for summary judgment, obviating the need for a trial. And then they give a general guideline for when the pretrial will be held, and that's not a firm date. That's just a general, time reference, and then a general time for the case to be tried for. And they call it a tracking order. What do they do in California? I'm just curious.
In California, the court, when they set a trial date, the Code of Civil Procedure has the times when you have to finish discovery, when you have to, when expert discovery occurs, you exchange your experts. So it's all governed by the Code of Civil Procedure. So the Code of Civil Procedure is, I guess, the tracking order, but the judge doesn't issue that. He just issues a trial date, which starts all of the dates running. You have, 50 days before trial, you exchange experts, and it's all in the Code of Civil Procedure.
Oh, that's interesting. That's interesting. No, we get an actual printout. I could show you one of my cases because it's all public knowledge. Once it's in court, they give us the dates. It's only one page. Usually it's just one page. So in California, the court says, all right, the trial date is going to be April Fool's Day on 2027. And then you look at your code and kind of interpolate going backwards.
Yes. There's parts that do that that you can use to help you with that. And also in complex litigation, though, it is governed by the court. When there's a separate court called Complex Litigation Court, and I've been in that court. Actually, when I was a baby attorney, I was in that court, and it was not governed by the Code of Civil Procedure. It was a scheduling order that the judge gives because the case is like very complicated and stuff.
Interesting. Now we've got some interesting comments here. We've got Brian Jr.'s frozen donuts saying, I guess the video takes that off, but he says, "Sup peeps, I have a feeling our South African friend here is going to bring absolute flames in this case. I'm psyched to watch him work." He is speaking about the attorney for Karen Reed, Damon Seligson. I guess he was raised initially in South Africa. Then he moved over here and he was educated in the United States. And that's why he has a slight accent. That's all.
Well, his accent is very engaging. It's appealing.
Yeah.
It's like Rosie.
And he speaks clearly. It's not so thick. I can understand the man perfectly.
Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered in the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Hey, Broken Baker is here. We love Broken Baker. We watch you, and thank you. Welcome, Broken Baker, to see you join our humble little podcast, and we like having you here.
Your Honor, in a similar boat as to Waterfall, we were putting the finishing touches on our discovery responses. The last leg of it is just collecting communications from employees, the managing incidents, some of whom no longer work for C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of the response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would expect
Not how the court
that-
system likes this stuff to work, folks.
Right, I would
Dudes, you could read the newspaper, but I realize as an attorney, none of that stuff is relevant. So sure, he's going to play the, oh, I'm shocked and surprised card. That's all right.
expect the courtesy of a meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So with this.
So what the judge is saying is, hey, this is a wrongful death action. It was initially brought by the estate of John O'Keefe, Paul O'Keefe, his brother, being the executor of the estate. And the judge is saying, this is a wrongful death action. It's just a wrongful death action. That's all we're going to do, very narrowly viewing it. But as I explained earlier, there's several different ways that more than several different ways that Karen Reed's defense can go, and they want to broaden it out. I mean, wrongful death is one cause of action, but the civil rights cases and all the other matters are also things that Karen Reed's attorneys are saying, it all rises out of the same facts, so why make us file another lawsuit in another court and, kind of go down two different parallel train tracks, because that's going to be expensive, and it's really not good for the court system to have two different cases proceeding along the same tracks. But the judge's position is, nope, this is a wrongful death case, and that although there's other causes of action that the estate of John O'Keefe brought.
The emotional distress causes of action.
Yes.
It's interesting.
Yeah. And this hearing was also a hearing on Karen Reed's motion to dismiss the emotional distress claims. And we're not going to get into that because, it gets into some legal technicalities. If anybody wants to, over in the comments, ask me about that, we'll look at it. But it got more into the weeds of the legal requirements of those claims.
At its essence is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case, and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
I just want to point out what I pointed out before, but you couldn't see him, that there's Alan Jackson. He sat through the whole hearing. In a couple of minutes, I'm going to point out what he said after the hearing outside to the reporters, but in actual open court, he flew in from California, but there he sits.
The rule does require that, but the court has discretion to consider the streamlined approach, and we'd like to brief that for Your Honor, but we're raising it at the status conference so that because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case. Correct?
Yes,
there's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think, basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way we could, you wouldn't even have this procedural process outlined by the spring, most likely.
So I'm not sure whether one of two things, whether the judge, and that's Judge Daniel O'Shea, whether the judge is giving them a heads up that he just doesn't like this idea at all, and when they do file a motion to add a third party, that he's disinclined to allow it. I don't know if it's that, him giving them a heads up, or whether he's just telling them this is going to throw a monkey wrench into the case. We could try the basic initial case, the wrongful death and other associated claims that were initially brought. We could try them as early as next March of 2026. Maybe he's just giving them all a heads up. I don't know which it is. Do you have any thoughts about that?
It doesn't sound like he's going to be amenable to it. But what I think is, I think the civil rights claims should probably be separated. Because, I mean, to one extent, she wants to blame others for his death. And to that extent, certain people can come in because she can bring them in as pointing the finger at them since they're pointing the finger at her. And that's all one action. But the civil rights claims, those arise out of her rights that were violated or allegedly violated during the course of her criminal case. So I have a feeling he won't let in the civil rights case, but I don't know. I mean, it does arise out of everything, and it is for judicial economy, but those civil rights claims are separate and apart and have nothing to do with the O'Keefe family. And so I think I know in California, the civil rights case probably wouldn't be consolidated with this.
I see what you're saying. I hadn't thought it through as thoroughly as you had. So I see what you're saying, because what happened the night of January 29th, 2022, or didn't happen in that house, or in the driveway or whatever happened that night is between Karen Reed and the O'Keefes, I guess is what you're saying. In the civil rights cases against Mass State Police, Tully, Bukhenik, and former Mass State Police trooper Proctor, those civil rights actions are separate, and it's not the same nucleus of facts, really. Right. That delves into the shoddy investigation that was done. And also, I should have included in that the Canton Police Department, the Canton, as they say, Police Department. So, yeah, that nucleus of facts is a little bit different. But I think the gray area, and I don't know how it would be, you might be totally right about this. I'm just thinking out loud for the first time. Oh,
my God. Don't do that.
The gray, I know, really, it hurts.
No, go ahead. The gray area is what?
The gray area in between is, Brian Albert, the McCabe's, and Brian Higgins. What did they do that night inside of the house? That does have to do with what happened to Paul O'Keefe. At least that's the allegation by Karen Reed's attorneys. So I see what you're saying, that the initial case, the wrongful death case, the emotional distress claims, whether they go forward or not, that's one nucleus of facts, or ball of wax, however you want to characterize it. And the claims against the police for whatever they did in their investigation, that's a Section 1983 civil rights violation. But I'm just saying, in between, what do we do with the claims against the Brian Higginses and the Brian Alberts of the world?
It's overlapping. There's like a Venn diagram, and there are certain defendants that she wants to bring in as cross defendants that kind of overlap on both.
So, they
could file a separate lawsuit if the judge doesn't let the civil rights complaint, doesn't add the civil rights action into this action. They can file in federal court or state court, right?
Yes, they could file. I always thought that the federal court is more apt. I've done 1983 claims, and they're better in a federal court because the federal court just has more of an ability to handle that type of a claim. But I don't know. It does seem like it would be a waste of resources to bring it in the same court. I mean, third-party actions are allowed all the time. This is a very unique case. But just for example, suppose you're in products liability litigation, and it's a defective product, and you bring a case against the manufacturer of the defective product. And then you find out in discovery that there was somebody else that you didn't really know about that was involved in the design of the product and or the outsourcing of the manufacturing. Now you come into the understanding that it wasn't the company you initially brought a civil action against. It's some other company that the actual manufacturing took place. So that's when you bring in a third-party complaint. The defense always says, "Oh no, that's different. That's a totally separate cause of action. They're in some other jurisdiction." But no, under the long-arm statute, we can bring them in, and we often are successful on those arguments because the courts agree. Why make you litigate the case twice? I might bring it in the same court. I might bring it in the Suffolk County Superior Court or the Middlesex County Superior Court, and so. I guess what I'm saying is I wouldn't want to be in Judge O'Shea's shoes because it's a tough call. I mean, he's in control, and courts are granted wide latitude of discretion in that type of decision. Yeah. So let's finish up with this.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff, and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time.
I like that. Behemoth litigation. I like that.
That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve.
And there's Paul O'Keefe, the brother of John, and Peg O'Keefe, the mother.
Resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But you have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time. Just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case.
Marc Diller, the plaintiff's attorney for the O'Keefes, wants to keep it simple. He doesn't want them derailing his lawsuit. He was the attorney that initially brought the lawsuit, and he doesn't want them twisting it around with all the other matters. Remember that the people at the district attorney Michael Morrissey's office, are dead set on Karen Reed's guilt, even though she was found not guilty by two different juries, and that attitude carries over to the civil complaint, where they say she did it. They just want to keep the case simple, keep all of this conspiracy stuff out of here, keep the 1983 claims out of here, and I think he just wants to keep a clean piece of litigation, but it's not that clean. This case is anything but that clean, and I don't want to go down into the weeds of now they're talking about discovery issues. I don't want to go down that path, and they then do argue the motion to dismiss the emotional distress claims. That goes down into the weeds of, I've actually been to the appellate courts of Mass and New Hampshire on the issue of emotional distress, and it's a complicated issue. It's really whether it's negligent or intentional, and the type of evidence that's required.
In
it's
California, you have to be within the zone of you have to personally perceive it or hear it, see it,
or be in the zone of danger. Yes, yeah. The Massachusetts courts adopted your zone of danger idea. They actually, I forget the case. I forget the name of the case. Semino versus Milford Keg might be one of them. But
it's the cab company case. That's how in California, it's the cab company case.
But there was a case going way back into the 70s or maybe early 80s, the late 70s or early 80s, that the Massachusetts Supreme Judicial Court recognized your California decisions, and there were a ton of them, and the zone of danger.
Yeah.
And so that's... I really don't want to go down into the weeds. If anybody is really that interested in it, I'd be happy to read my briefs and go back into that. It's just that, I don't think it's really pertinent at this point to talk about in this particular case. What I do want to do is go to an article that kind of highlights what we just saw in this case. This is an article that was in the Boston Herald, and it basically focuses on some of this. There is Karen Reed talking with her attorney, Damon Seligson, in the courtroom Monday. And this is the Boston Herald. I don't know why we don't have their head banner, but I found this part interesting here. It just focused in on the issue that we've been talking about. The 10 new parties Reed's attorneys aim to bring in with affirmative claims represent a who's who of characters from the criminal trial. They include the Massachusetts State Police for alleged negligent training and retention of troopers, Reed's former state police investigators Lieutenant Brian Tully, Sergeant Yuri Bukhenik, and Michael Proctor for civil rights violations, and the Town of Canton for the local police department's negligent failure to secure the garage and sally port. And I guess that paragraph right there is the part you're saying really doesn't have any place in the initial litigation.
Yeah, that's
okay.
true.
But then my gray area, I don't know. Reed's team also told the court they intended to file civil rights and civil conspiracy claims against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were in the house O'Keefe was found outside of. So I don't know. It's kind of the same. But I see your point that it's civil rights and civil conspiracy claims. That would certainly muddy up. I can see why the attorney for the O'Keefes, Mr. Diller, wants to keep that out because that really would muddy the whole thing up.
It would. Yeah.
That would muddy the whole thing up. But
And it would take a while to litigate all these parties. I mean, if some case like this ever happened in California, they would send it to the complex litigation. If the judge was going to allow all these parties, it would go to complex litigation.
Well, Massachusetts has a business litigation court, but this isn't that.
Yeah.
As far as I know, correct me if I'm wrong, as far as I know, we do not have a complex litigation section. Sounds like we should. So then the other thing that's interesting in this article to me was this report. As you saw, Alan Jackson was at that hearing on Monday, September 22nd, 2025, but he sat silent while other attorneys spoke. Following the hearing, Reed's attorney Jackson argued, quote, every single word that you heard in there was basically parroted right from Michael Morrissey, right from the prosecution. Quote, and this is Alan Jackson again, maybe somebody should check the tapes because last time I checked, those arguments were put forward in front of a jury and the jury spoke very, very loudly, not guilty, said Jackson, and not just not guilty, when the jurors were asked, innocent. So I found that.
Yeah, because they never proved a collision. That's what the jurors found. There was no collision.
That's right. And the ARCA experts, there were two of them that said, A, there was no collision between the vehicle and John O'Keefe, and B, John O'Keefe was not hit by a vehicle. So. Yeah,
the aperture experts, that was a guy that lied about his BA or said he had a BA when he didn't.
He's been, well, Yoli, I'm not correcting you. I'm just pointing out that he's been working on it for 18 years. Do I have that wrong? Maybe he's been working on it since 2008. Yeah, that's 17 years. Yeah.
I don't understand how that guy wasn't an expert. And for the Commonwealth on top of that.
That's like the character from Animal House. Even he got his bachelor's degree in 7 years, something like that. Which reminds me of a very sad thing I have to report. I have to report a very sad thing. And that is that Laney Law is no longer going to be able to work with us. We had a really nice, long conversation. She was in my office the other day. We talked for an hour. It was a very friendly conversation. It was very, congenial. We've always gotten along. We've had our little differences of opinion, but we've always she's almost like a sister to me or a daughter. You initially thought she was my daughter, but she came into my office and we had a nice long conversation. And I don't want to dox her and say anything at all about what she's doing, but the other things in her life are just too busy. So she's not going to be co-host anymore, and I'm very saddened by that. I enjoyed working with Laney Law. I am of a generation that we're not totally up to date with all the technical stuff, so she really helped me, do the technical stuff with YouTube. And even when we had this nice long conversation last week, the next day, sure enough, I was having a couple of issues, and I texted her. She texted me right back and helped me straighten that out. So we agreed that she's welcome to come back on a special panel type of arrangement or special arrangement. Maybe we'll have an end of the year episode and review things. Maybe we'll have a Christmas episode. I don't know. I'm just thinking out loud again. I do that a lot. I think out loud.
Yeah, I think. Well, I'm gonna miss Lainey too, because she was a sweetheart, and she was like the one that asked questions that I didn't think about. Like, oh,
Yeah. Yeah, she made me think. I could talk all day about the differences between negligent infliction of emotional distress and intentional infliction of emotional distress, and the different types of evidence that are required, and manifestations of objective symptomology. But she would say, "What are you talking about? What do those terms mean? Come on down to our level." So anyhow, the next thing I wanted to talk about is we read the motion or portions of the motion in one of our previous episodes of the Marc Diller mega motion to dismiss the case against Aiden Turtleboy Kearney. And what I didn't go into, that itself was 36 pages. There was an affidavit attached to it that was 88 pages. And so I was certain to read it, but we try and keep our episodes short. We respect the creators that can go on for an hour and a half, 2 hours, 3 hours. That's fine, but that's not us. We drop episodes on the weekends and sometimes do a midweek thing. So I went back and read the affidavit. And the affidavit was very interesting in terms of breaking down different topics. And one of the topics that was involved was Kate Peters' intense involvement in, well, we'll just say it, getting her former boss, Aiden Kearney. And give me a minute, and we will bring this up. So this is the affidavit. I'm on page 38 now. This is the affidavit in support of motion, Commonwealth versus Aiden Kearney, docket 2382, CR comes now. I'm not going to read the whole thing. I'm just pointing out that this is an affidavit that was brought by Marc Diller, an attorney admitted to practice law in the Commonwealth of Massachusetts, pro hoc vice, affirms under penalty of perjury as follows. And it goes on. So let's see if we can fast forward to page 35, which is where I was.
Now, Mr. Diller really knows how to lay the foundation for evidence, I'll tell you that.
Yeah. Miss Peters' history of dishonesty and fraud. And that's not where I wanted to go. I wanted to go back, or I wanted to go forward.
To the video?
Ms. Peter immerses herself into the case. On information and belief, for years, Ms. Peter has spent several hours a week online monitoring and cataloging Mr. Kearney's content, mining for material to use against him. Ms. Peter had no public interest or stake in the Reed case and no association with any witness in it until Mr. Kearney began supporting Ms. Reed's innocence. Naturally, once Kearney started to support Ms. Reed, Ms. Peter became a self-styled advocate for Ms. McCabe, the Alberts, and the O'Keefes, and sought to foster relationships of convenience with others who hated him, including Lindsay Gaetani, who shortly after meeting Ms. Peter became the alleged victim in the 2024 witness intimidation indictment against Mr. Kearney. So it goes on. September 13th, 2023, Ms. Peter publicly bragged that she had archived a purportedly illegal recording made by and we're not going to use that word, Mr. Kearney, of his conversation with Stephen Scanlon, a private investigator who was tangentially involved in the Reed case. So this goes on. It's well written. What I want to point out is that she was instrumental in telling Massachusetts State Police when he got his kids on the school bus, where he got his kids on the school bus, and, kind of laid the foundation for them to go arrest him after he put his kids on the bus. 173, Massachusetts State Police audio transmission from immediately before Mr. Kearney's arrest revealed that the arrest team, a fugitive unit which included Detective Lieutenant Tully, heard from Kate Peters, who was the same thing from yesterday. 2 older kids getting on the bus around the same time, but it was 8:30. So tell me your thoughts while I find that audio. Because I know I have it. I just have to dig it up here.
So Cosgrove resigned from the fake victim case from the.
Yeah. Is that something? Yeah.
Yeah, it's crazy.
Is that crazy?
He was a special prosecutor too.
Yeah. He's a retired Massachusetts Superior Court judge. I kind of have dim memories of appearing before him, but whoops. Did you hear that?
No.
Okay, good. So what I need to do is this video. It's worth waiting for. It's worth.
Yeah, I haven't seen the video. The hyperlink. If you
It's you gotta go through channels to get it, but
if you just hit the link, it doesn't work.
On most of the versions of the document, it doesn't work, but I fiddled around with it. I didn't even need Laney, but I figured it out. I don't know why I keep getting. I don't know why I keep getting that, but
What's this letter?
All right. You know what? We'll do it on the next episode because it's interesting. It's interesting to hear for some reason. I know I downloaded it this afternoon and I played it back. And I'm just going into my video files. And for some reason, I can't pull it up. But it actually, it documents the police basically saying, oh, yeah, there he is. Yeah, okay. Don't do anything until I say, oh, get into your positions, hold your positions, don't do anything until I tell you to do it. And so it basically, and it's interesting. We'll do it in our next episode. I promise we'll do it in our next episode. And I promise that I'll have it queued. Wait, what's this? I think I found it. Is this it? Hang on. No, I guess not. Interesting. Interesting. It's really worth. And this is one of the reasons I don't really like doing lives. I shouldn't tell people I don't really like doing lives. I shouldn't tell people that. But this is one of the reasons I don't like doing live because, as you know, you'll have the ability to mess things up.
You should have emailed it to me, and then I could have brought it up.
I know. Maybe next time. Do you want to be the technical director from now on?
Well, I'm not all that great, but I mean, I can help with whatever I can.
That's what they call it in the TV business. The guy that's behind the scenes pushing the buttons, he's the technical director. And
Rainey was good at that.
Yeah. Anyhow, okay, let's move on. And I promise that I apologize that we don't have that. We will play. It's worth waiting for. We'll do it in our next episode. I'll cue it up and have it ready. But it's just at the urging of Kate Peters, they know where Mr. Kearney drops his kids off for school, and they wait, and they wait until the kids are in the school bus. Then okay, let's go. So, I mean,
that is so bizarre that Kate that Peters was so involved.
Yeah, it's ridiculous. Oh, what do we have? What do we have this week in terms of comments? It is time for all the corruption to be exposed. Pin it on the girl didn't work. Betterow will be there. Candy Adams says sad about Laney. Okay. Bada Bob. Bada Bob. Is that the creator? Bob?
Bada Bob?
This would appear to be a very novel action from Karen Reed. In my opinion, this isn't going to fly. I do wish Karen Reed the best and think this action by the O'Keefe family is weak. Yep. I would tend to agree with that. Okay, why don't we go to our viewer comments
Okay.
this week? We have 10 of them, and they're all mixed up as to different cases. We have comments on Karen Reed. We have comments on Turtle Boy. We have comments on the sheriff, Mickey Steins, who shot the judge. Can I say, we have to respect the presumption of innocence.
Right.
But it's
Right.
on video, so can I say that he shot the judge or not?
Well, nowadays with AI, I never know. I mean, videos can be tampered with. I'm not saying that it was tampered with in that case. He obviously was kind of admitting it when the cops were questioning him. But we still have to presume he's innocent because he could have been impaired and he would be maybe, I don't know how it works in Kentucky, but he might be,
Yeah, no, I agree
impaired.
with you. Okay, you taking the odds or evens this time?
I'll take the evens.
Okay.
Oh, yeah.
You're-
Okay.
You're on.
Made of Questions is asking, they're just going on to deny, and Tully is going to say he checked everything and this will drag on and on. This just isn't a fair trial. If the judge was really calling balls and strikes, it would get dismissed. But I've seen so many times now proof come up that should get charges dropped, and yet the trial keeps marching on. Reed, King, Walsh, and now Kearney. It will bite Tully in the butt if this gets to trial. He will look like a fool trying to explain how he both reviewed all materials, never opened links, and somehow only used out of context, mistitled clips in the grand jury.
Yeah. There's just so much in that case. There's just so much. And we've done full episodes on it, so I don't feel too bad going on to the next slide. From Kiwi D5P, an evidentiary hearing is going to expose a whole lot more. Who doesn't want to see some of those players back on the stand under the questioning of Mr. Betterow? The bad actors will be praying it all gets dismissed. That could be. Because in the motion to dismiss, which we focused on in a previous episode, I think 2 episodes ago, written by Marc Betterow, he gave the court the option, just dismiss the case. If you don't want to dismiss the case in this posture, then let's have evidentiary hearings. So I had made a comment about, I wish they wouldn't have given the court the option and just dismissed the case. But it was pointed out to me by commenters, no, these evidentiary hearings would be a good thing. And that's one of the comments that went that way.
Okay. So the request for an evidentiary hearing was genius as it boxes the judge in. Otherwise, the judge could say that there were Rule 14 violations, but no proof it was deliberate, so let it go. This way, it's a lot harder for the judge to weasel out of it. Interesting.
That is an interesting comment because, it, with the number of violations in all the different cases, but of course, the judge in one case isn't going to accept evidence from another case, but it just seems so obvious that, there was a lot of monkey business, and it's either total incompetence or deliberate. I think it's a mix of both. I don't know.
Right.
Number 7, Made of Questions. The titles being changed is the least of my concerns regarding this case. The clips attached to the mistitled videos taken out of context and presented as complete videos is far more concerning to me personally. They'll use some excuse saying they never said they were complete videos or that they never represented the titles as Kearney's titles. Cosgrove will blame Mello for the uncharged accusation of wiretapping, and the judge will just roll with whatever pathetic excuse the state comes up with to justify all their tomfoolery. I have zero faith in the court to have the guts to do what he knows needs to be done to fix this wrong. It's sad, but I have no faith in these people at all. And I just want to comment about this comment that we get people that go into our comment section, well, you don't understand, or what's the matter with you? You're a moron. You don't understand this. No, this guy took something that I said, and rather than saying you're a moron if you think, no, he added to that. We had focused on the videos and the fact that the clips had been retitled to, for example, instead of having the full title, which was a lengthy title, I don't exactly remember, they took that and then they renamed it intent to, get this person, or, I could take out Colin Albert or something like that. Instead of saying, Attorney Myers, you're an idiot, to say that. No, this guy made a point. That's not, that's the least of my concerns. Here's what my concern is. So that's what I look for in our comments, is for someone to, instead of, attacking me, which happens all the time and I really could care less. This guy added to the conversation, made of questions. Thank you for adding to the conversation and keeping it professional and, on track.
Yeah. Okay, this is Prof. Tarfeather. I've been collecting rubber ducks since the early 1990s. It's a real thing. I love the humor. Every year in Northern California, we have the rubber duck race down in Sacramento River. All of the proceeds are donated to Children's Medical Services. The MSP put more effort into looking into this than several murders.
Yeah, remember that? Remember that was the police report was what, 37 pages, something like that?
Yeah. And there is a duck race. I forgot about that in Northern California.
I think there's others. I know there's one near where I live in Nashua, New Hampshire, which is right on the border, maybe, I don't know, 25 miles north of Boston, and they have a duck event. I don't know a whole lot about it, but I know every year they put ducks in the river, and the money goes to charity. It's a cool thing. Now, I have a question. What do you think? I know a young woman who has ducks all over. You know that whole thing where people have Jeeps and they put ducks all over their Jeeps? Do they do that out there in California? It's a thing.
No.
I never knew about it, but I know a young woman who has a Jeep, a nice Jeep, and she has ducks all over it. I'm like, what is that? And she told me she goes to these events in Canada and New York and other places where they people with their Jeeps parade around with ducks.
I never heard of that.
Yeah,
that I've never heard of.
It's a thing. And so I asked her if she'd let me do a short on that, because I think it's kind of interesting. And I don't know. I'm going to ask my viewers, should we do you want me to do it? She's reluctant to do it. She's very reluctant to do it. So let me know if I should tell her that my viewers, demand that we do an episode on Jeep ducks. Jeep ducks. Yeah, it's a thing. I never heard of it. Number 5 is, aren't you doing the evens and I'm doing the odds?
Yeah, go ahead. I'm sorry. Go ahead.
Misty and Eddie. Always love listening to your expertise in all these matters pertaining to Aiden and Karen. Although it is serious content, it is very entertaining to say the least. Now, remember, I made fun. I said I liked the language in Bettero's affidavit, and I pointed out sheepishly, and I pointed out the use of the word regurgitating, where he could have just said, but no, he added the word regurgitating. So Misty and Eddie says, sheepishly turning in his morning, however, did find me almost regurgitating my breakfast, firstly from my utter disgust at the antics of Cosgrove prosecution's sad sack of misfits, but secondly, and important for one's sanity in all of this nefarious nonsense. Remember, Jennifer McCabe said, well, I'm not doing anything nefarious. Laughing at your take on it. Love your work. Cheers from Tasmania, Australia. Yes, thank you.
Okay, this is from Blueberry the Great. If you're ever looking for material
I can't hear you. What happened?
Oh, what happened? You can't hear me?
I can't hear you. All of a sudden, I can't hear you. Did something happen?
Can you hear me now?
Yes.
Okay.
Go ahead.
All right. This is from Blueberry the Great. If you're ever looking for material to, post about content, I think a publicly open study guide to the bar would be widely appreciated by most and highly viewed. Any sort of educational series of the law would be greatly appreciated by the public, I'm sure. That's interesting.
I can't think of anything more boring than doing YouTube episodes. Yeah. I can't think of anything more boring. What about you?
I don't know. I think I would like it.
Really?
Yeah.
Because, we all do. I assume we've never talked about this, but I assume you did some kind of a bar prep course.
No, I didn't.
Oh, you didn't?
No.
Oh, wow. I'm impressed.
No, I passed the first time. I studied
Wow.
on my own though. I had books. I didn't
Yeah.
go to the actual classes. I had the study books.
I went to a course, I don't know if they're still around, it's called Barbary, and they gave us outline books. They gave us outline books on the various topics: constitutional law, negligence law, real estate law, uniform commercial code, one of my favorites, tax code, another one of my real favorites. And so, but yes, I went to twice. I went to the training classes in Boston for the Mass Bar. And then I did it all over again for the New Hampshire bar, but I didn't go to the classes. I just watched the videos because I didn't feel like driving up to wherever the heck. That was in February, so the course was in the winter, and I didn't feel like driving up there. So, yeah, there are videos, but I'm sure you have to pay. I don't remember. It was so long ago. But would you?
I mainly did practice tests because in California, it's all about the test taking, like skills and studying an outline wasn't putting it into active practice. So that's what I did.
Really? You really think somebody in our audience would like us to do the equivalent of a bar study thing?
This person does.
That's one person.
Yeah.
Let us. You know what I. You know what I think would be the most boring thing is a podcast on uniform commercial code. Was that in the California bar?
Yes. No.
Yeah.
I did not like that.
They kind of want. Well, actually, a friend of mine in law school who's now practicing for banks primarily was really into that stuff. So I would always, to this day, the few times more than a few times I've had uniform commercial code issues, I just call him on the phone, and he's used to me calling him on the phone and asking him, well, Article 4 and Article 9 have been completely revised since I took the bar. And so, anyhow, people probably don't know what we're talking about. All right. Thank you, Blueberry the Great, for the idea. I don't know. So now we go to number 3, and now we get to Mr. Koberger's case. Alan Sanderson, R5U. Why is this murdering waste of oxygen still breathing 3 years on after what he did? There is absolutely nothing special or interesting about him. Okay. The majority, and we've asked on several different episodes, we've asked our subscribers to please let us know whether we should stay on the case or move on. I'd say 95% of the people that comment say, stay on the case. There's so many different questions. Stay on the case. Keep looking at it. Keep looking at the documents. They are, going over the court documents at such a slow pace that they probably want you to take your eyes off it, was one of our commenters. So, Yoli, I think we should stay on the case.
I think so, too. There's sealed documents that came out today.
Really? I didn't see that.
Yeah, they're just basically sealing things based on privacy, sealing things based on, witnesses being endangered by harassment.
Oh, wow. So you're more on top of it than I am. Have you had a chance to look at them? Is there anything I need to take a look at? And do we need to do an episode on it?
I just skimmed through them, but it's probably not anything worthwhile, but I'll take another look at them. But
I will too. I'll take a look. Is it on the regular court website where everything else is? Okay, I'll take a look at it between now and the next time we sit down and do episodes. I'll take a look and see, if there's anything worth going into.
Okay, this is from Striving for Titus 2. Allegedly, that courthouse actually had another room that was a smoking room. Allegedly, everyone is aware of this. Allegedly, locals are not as shocked as the rest of the world.
Well, all right, that may be. It's not really that relevant to the case, but I did look into it, and Kentucky does have a law in the books that that smoking is not permitted in public buildings, but there may well be an exception if there's a designated area. That's fine. And the number one comment from Kookie Karelian, she's been a regular more or less, and she says, please stay on the case, especially when they start releasing the court documents. It would be interesting to hear a lawyer break them down, and no other LawTube channel is on the case anymore, so I'm all for you guys. Well, there are a couple of other channels. There are some creators that have walked away from it, but we have not. We're still looking at it, and there are a couple of others that are out there still looking at it, so we will do it. And I guess that's about it. I don't know what I just did. My screen's going. My screen is going crazy, but we're both still here. So I didn't do anything too bad. Any interesting comments in the comment section?
Oh, they're just talking about where Mr. O'Keefe was in the hearing. Yeah, I mean, just comments on where they can get information on Cosgrove resigning from the case. I think that would be on Turtle Boy's channel.
Here's Scott McGinnis. He says that the O'Keefe's civil suit is foolish. The most they can hope for is that the two bars settle. Otherwise, it's ill-fated. Yeah, they've got a tough claim against the against Karen herself. I mean, the ARC expert said there was no collision, there was no contact. So, maybe it's time for us, I mean, it's obvious to you and I, but maybe it's time for us to comment just a little bit on the distinction between beyond all reasonable doubt and a preponderance of the evidence. Have we pounded that into the pavement, or is it worth commenting on that really briefly?
It's worth commenting on just so that people know. I mean, those who think, well, Karen was found not guilty, why are they bringing this? And it's like the OJ case, basically. OJ was found not guilty of unaliving his wife and her friend, and yet the Goldmans, the family of the one friend that was unalived, they brought a civil suit and they won, and they had a judgment against OJ Simpson. So
Right.
The bar is much lower for the civil suit.
Right, and that's just generally true across the country in all the courts, that in a criminal case, the prosecutors, the state, the Commonwealth, whatever the jurisdiction is that's bringing the claims, has a burden to prove their case beyond all reasonable doubt. That's a very high standard, whereas we civil attorneys, I talked earlier about a products liability case. Those are tough cases, but nonetheless, the burden of proof is just a preponderance of the evidence, as they say. You tip the scale just a little bit. Or the way some have suggested, and I really don't like the jury instruction in Massachusetts on this issue, but the way some have expressed it is that beyond all reasonable doubt is carrying the ball down into the end zone, whereas the preponderance of the evidence standard is just taking it over the 50-yard line to the 51-yard line.
Yeah, and this is such a highly publicized case. Selecting a jury is not going to be as bad as a criminal case, but I mean, almost everybody's heard of this case, so they're going to probably be aware that she was acquitted.
Yeah.
So.
Yeah, how could you find, well, I shouldn't even say this because I know better, but how could you find anyone in Massachusetts, even Plymouth County, where this case is now in that jurisdiction, how would you find anybody that didn't know about Karen Reed? I mean, it's been big news now for 3.5 years. How would you find anyone that didn't know that she was found guilty? So I don't know. Here's a good one. You've been ducked. It's a thing with Jeeps. Yes, it is.
I didn't know that.
Can we?
That was crazy that people were putting ducks around, and that was a threat.
Yeah, for a while we had ducks in our studio, but we kind of retired the ducks. They're still in a box in a closet. Phoebe Mick says, and can we please stop calling him JJ? This is not a kindergarten class, and his name is Officer O'Keefe. Do you really want the court and the jury to see him as a child? Yeah, that was kind of silly.
I agree with that. Yeah, they should call him Officer Keefe.
Yeah,
O'Keefe, because that gives some respect to his name. JJ is kind of like I don't know.
Yeah, I think they're just trying to personalize him as much as possible. They're just trying to personalize him as much as possible. Let's see. I saw another interesting one here, but now I lost it. That's me. Absolutely. Scott, Phoebe. Here we go. Did I put this one up before? Yeah, I put that one up before. Yeah. And a lot of people are saying that, the bars, I would imagine have what's called dram shop insurance. Mm-hmm. And so you would think that the cost of litigating this case, you're going to have experts. And, just the cost of litigating it, doing all the discovery, the interrogatories and the interrogatory answers, the requests for production of documents, complying with that, and going back and forth, because defendants never, in my experience, civil defendants never take their discovery obligations seriously. And you have to push back. You have to have conferences with them under the rules, and then file motions to compel. That's my experience. But I don't think defendants really take their discovery obligations seriously. So my point is that the dram shop insurers want to make sure that they can cut their costs. That's all insurance companies care about, by the way, is cutting their costs. They want to cut their costs.
Yeah, so they may offer the cost of litigation at an amount that it would cost them to litigate the case as a settlement. But, I don't know if the O'Keefes would take it.
Yeah, I agree. That's it. Do you see any other comments we ought to bring up? Or are we...
I think we're fine.
All right. All right. Yoli, thank you. Do you have any closing thoughts for us this week?
No, I guess the Turtle Boy motion is tomorrow. He's in court.
Yes.
So
yeah, he's in court at 2 o'clock in the afternoon.
I'm going to try to watch that.
Yeah, and if it's eventful, which they always are, we'll do an episode on that, hopefully. And I'll take a look at the Koberger documents that you mentioned. I didn't even know that they dropped. I was at work this afternoon, and I ran home to Studio B here to do this episode.
And then you'll play that video, or the video of Turtle Boy getting arrested.
At the school bus stop. So for an emoji this week, I have one. How about a school bus? How about a school bus? So give us a school bus. Yoli, thank you very much for your time. And thank you for watching our live.
All right. Thanks a lot, guys.
Hang on. Remember to be nice. Be kind to people, especially in our comment section. Please, please, please be kind in our comment section. I pointed out that one comment where rather than, saying all kinds of nasty things, the guy said, that's not what's important to me. Here's what's important to me. Don't tell us that we're stupid or we missed facts or whatever. Add to the conversation and help us out. Be nice.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.